Greetings to all of our subscribers and supporters, and those that are still on the bench waiting to subscribe and support. We appreciate all of you. King Channel TV here again. A lot is going on with the Fani Willis saga, and we're bringing you the latest news updates. Don't forget to like, subscribe, and share the video. Click that notification bell. Yesterday, Fulton County Superior Court Judge Scott McAfee heard motions to quash defendant Michael Roman's subpoenas, which allege Fulton County DA Fani Willis and Special Prosecutor Nathan Wade are in a romantic relationship that represents a conflict of interest and constitutes misappropriation of taxpayer funds. From Michael Roman's allegations, the court scheduled an evidentiary hearing for Thursday, February 15, to determine if the allegations can be supported or proven. Since the filing of the allegations by Michael Roman, the district attorney's office has strongly opposed and tried to stop the escalation of the allegations. But actions taken by the DA to curtail or stop the allegations have only made them more widespread. In this video, we review the quash motions submitted by opponents to the evidentiary hearing, the judge's decision, and the reasons for his ruling. At the beginning of the quash motions hearing, the judge made brief remarks on how he will handle the evidentiary hearing and that the hearing could not be canceled.
I just want to make my initial observations and findings of where we're going today and the rest of this week. So several of the motions to quash today are arguing that we shouldn't have a evidentiary hearing at all and that quash is appropriate on those grounds. So to that end, in studying the law that's been filed up to this point, I think it's clear that disqualification can occur if evidence is produced demonstrating an actual conflict or the appearance of one. And the filings submitted on this issue so far have presented a conflict in the evidence that can't be resolved as a matter of law. Specifically looking at defendant Roman's motion, it alleges a personal relationship that resulted in a financial benefit to the district attorney, and that is no longer a matter of complete speculation. The state has admitted a relationship existed. And so what remains to be proven is the existence and extent of any financial benefit, again, if there even was one. So because I think it's possible that the facts alleged by the defendant could result in disqualification, I think an evidentiary hearing must occur to establish the record on those core allegations.
As Ashley Merchant, attorney for Michael Roman, moved to support the subpoenas she issued, Anna Cross, representing the DA's office, delivered arguments against her subpoenaing almost the entire DA staff, calling it a fishing expedition, and that none of those subpoenaed had any relevant information.
Ms. Merchant has subpoenaed a total of 9 employees of the district attorney's office, including the district attorney herself. The state's position is, and I think the evidence is clear, that these witnesses who Ms. Merchant or no opposing counsel has ever spoken to cannot be in good faith represented to the court as having information that would be relevant to any of the individual issues that the court has identified to being of interest. Ms. Merchant nor anyone else can represent what they would say. These witnesses have nothing at all to add to the allegations that were made. The affirmations and the facts sworn by an officer of the court that were made are categorically true. They're 100% true. And there's no witness, certainly none of the 9 that were subpoenaed, that are representative of the district attorney's office that will say otherwise. A criminal defendant does not have the right to make claims without admissible evidence and then subpoena the other side in an effort to conjure up some evidence to support them. That's not serious. That's an abuse of the subpoena power. It's the defendant's burden, now that the motion to quash has been filed, to establish the relevancy. And the state believes that there's just no way to make that claim in good faith, given the record that's before the court now. My understanding is that of all of the witnesses subpoenaed, there will be no individual who has relevant information that would dispute the affirmations in the Wade indictment.
All right. And so let's put the district attorney and Mr. Wade in a separate category. I think you would still, now that the motion has been filed, need to make some kind of showing for the other 7 witnesses challenged by the state, focusing solely on whether defense counsel has made a good faith basis to show that the relevance of these witnesses, even though, she may not have talked to them or they didn't want to talk to her. Why is quash still appropriate?
Quash is still appropriate here because even Ms. Merchant's recitation to the court of why these witnesses are relevant displays a misunderstanding of the role of these individuals.
Just to get over that threshold today, and Ms. Cross, I'll let you have the last word here, but I don't know how many times, or you may have argued at a closing the pattern instruction that a single witness, if believed, can establish a fact. What I'm hearing is again emphasizing the conflict in the evidence, and if the state it sounds quite confident that it's going to have an abundance of evidence to show these things are not true at the hearing, but I don't see how I can make that determination on the front end without live testimony subject to cross-examination and an assessment of demeanor and everything else that goes into those kind of determinations. I don't see a way around that. Any final thoughts for me?
Only, Your Honor, that I'd ask the court to hold or reserve ruling on the state's motion to quash until Mr. Bradley, who appears to be the sole and primary source for the allegations that have been made, until he testifies at a hearing. And then if you're not otherwise inclined to quash the subpoenas, that they be revisited at that time.
All right. I think that is appropriate. So to that end, one thing I would share is that obviously, as we've talked about, the rules of evidence would apply, but this is much more so than I would do in front of a jury. I plan to be proactive about the application of 403 and 611. And so if there's anything that's cumulative, if there's anything that is referring to, as in the words of the rule, harassment or undue embarrassment, I'm not going to feel inhibited from stepping in, even without an objection from counsel, to move this along and keep it focused on the issues at hand. So to that end, I do think that, again, under the court's authority to control the order and manner of presentation of the evidence, it would be important that from the outset, we're not talking about calling Ms. Willis as the first witness, and we need to get over a few procedural hurdles before we can get there. So I agree with Ms. Cross on that point. So, however, when it comes to the issue at hand, I think Ms. Merchant has established a good faith basis for relevance, and I don't see how quashal can be imposed here.
Well, there you go. The judge has ruled not to quash the evidentiary hearing on February 15. He also plans to be proactive and will step in to alleviate harassments, cumulative attacks, etc., even without objection from counsel. This appears more in line with protecting the defense. This brings our video to a close. Please like the video, subscribe to King Channel TV, and click that notification bell. Peace.